right, everyone, we'll get started. So most of you have submitted your assignments. Big sigh of relief. Marking has started on them, and the idea is that for everyone who submitted on time, the idea is that you will get those marks back across week 12. And of course, anyone that's had an extension, there's one or two across the two courses, the marks will be coming back a bit later than that. So well done on getting them in, and now the task is to absorb the sheer brilliance of what you have done and grade them and get those marks back to you. This week in the pracs we started preparing for the exam. And that's led to people asking a few questions in terms of, well, what's the best way to start approaching the exam? Now, where's my slides? Oh, that's good. These are my old slides. Anyway, don't ask me where my slides are. There's a couple of missing slides, but they should be up on the Blackboard site for you. So I updated a revised set of slides. It's got a couple of extra PowerPoints on it about preparing for the exam. And I'm not entirely sure why it's not saved in this version. I'll just do a very quick check and make sure it's not easily found. So one of the things that I wanted to point out is that it's good to have a look at the information sheet that's up on the Blackboard site about the exam. So that's going to tell you what types of questions to expect, what you should take in with you, and how best to prepare for the exam. So if you haven't had a look at that, go and download that from the Blackboard site. There's one for each of the courses because the exams are different between the undergrad and the postgrad courses. In the pracs between now and the end of semester, we're going to do practice scenarios, and we're also going to do two past exam papers, the 2012 and the 2014 papers. What you'll find is that the questions that will come up in the end of semester final exam, they're going to be similar format to what has been in previous years. The difference will be the facts that are included in the various questions and the various scenarios. And one of the things that you can do is, for the essay questions, is you can prepare model answers ahead of time that you can then bring into the exam with you and modify once you read the particular facts that are required from you for the essay. So, for example, there's always been an essay question that looks at the need for approvals for some sort of new development and so on. So you would look at the different assessment approvals that would be required at a state and a Commonwealth level, if that's what the facts are pointing to, and you would have your written essay answer to go ahead with. So for things like that, we're not going to give you an example answer for those essay questions. Part of the learning process is that you absorb what you've learned in the lectures and you translate that into your own model answer. But it is also something that you have time to prepare beforehand, so you've got a bit of lead-in for it. The other thing, of course, getting the most out of the practicals. Make sure you've downloaded and read the practical before you come along. Those 1-hour sessions are incredibly short, and if you're trying to read the material in the practical, it's really sort of slowing down the learning process. I've said to the pracs this week, make sure you print it out. Make sure you're working off the paper copy, because that's what you're going to be doing in an exam setting. And again, when you're writing your answers, make sure you're using pen and paper, because that's what you're going to be doing in an exam setting as well. And the other thing I just wanted to remind you is to make sure you've downloaded the enforcement guidelines, because you'll need that for the practical next week. The practicals won't be repeated, so make sure that you're in your allocated class, make sure you're doing the set practical for the week, because we won't be repeating them before the exam. So make the most of the learning opportunities that you have. So the lecture today is, of course, very relevant to the exam, because one of the things we're looking at today is the Commonwealth EPBC Act and the approval processes and the assessment processes that apply under the EPBC Act. Now, one of the changes that I made to the course when I took it over this year was I reduced the number of topics that we had to cover in the course because I felt it was a little bit dense. And the other thing I did was I reduced the number of slides that we had each week, which you may find hard to believe, but I've probably halved about the number of slides that are given to you each week. For example, the mining one used to have 220 slides, and I halved that, and so on. So what it means is that you're getting the material across 2 lectures, for example. So we had 2 lectures on the EPBC Act instead of just 1. So we covered the same material, but at a slower pace. Same for the EPBC Act. We've got 2 lectures. So this week we'll talk about the triggers for the EPBC Act. So when does it apply? And next week we're going to talk about the issues with enforcing conditions of approval, and we'll look at a couple of case studies for that. But before I do that, I just wanted to do a quick refresh of where we've come from with the EPBC Act, because I know those lectures fell at a busy time for you. Just a reminder for those that may have missed week 7 or 8, or it's on your list of things to do to catch up. Just remember that it will be on the exam, and you need to know the offence provisions and the different components of those, and the defences, which of course was one of the things that we looked at this week. So particularly the general environmental duty, and for those of you that did the prac this week, you would have realised the importance of having a good understanding of that duty and how you can comply with it from a practical point of view. And my apologies to the postgrads who are doing this prac next. You'll find out when we get in there. We also looked at contaminated land, and we looked at restrictions on the ability to deal with the land. And we looked at the different mechanisms that are put in place for dealing with contaminated land in Queensland. And that, in a nutshell, is what we covered across those 2 weeks. So why do we have a Commonwealth Act for environmental protection? Well, it comes from international developments. It's a reaction to the fact that we have these international conventions that have been agreed to by Australia, which are establishing duties on Australia as a country to protect the environment. So we have things like the Ramsar Convention on Wetlands, we've got a Convention on World Heritage, one on biological diversity, climate change, and so on. We'll talk about climate change a little later on in semester. The other ones, you're not going to be examined on these. It's just to give you a context. And for those of you that are interested in this sort of thing, there is a companion course that goes with the one for this semester that looks at international regulatory frameworks and climate change that goes through a number of these agreements. So you remember way back at the beginning we looked at the powers of the Commonwealth to make laws for the peace and order and good government of the Commonwealth, and there's a whole range of categories under which the Commonwealth of Australia, so the federal government, is able to make powers. And one of those is the external affairs power that you can see down the bottom of that slide. Now, the external affairs power is has been interpreted to refer to these sort of agreements that I just listed before. And that's where the Commonwealth's power comes from in terms of making laws, in terms of environmental protection. So, for example, if we look at the Ramsar Convention on Wetlands of International Importance, it has quite a significant impact on the sort of things that we can and can't do within Australia. So parties, that means each country, has to identify suitable wetlands within its territory to include on the list of wetlands for international importance. And those wetlands will be selected in terms of their ecology, botany, zoology, limnology or hydrology, and so on. They also have to put in place planning, okay, so we're looking at planning and approval processes to promote the conservation of the wetlands that are included in the use, and as far as possible the wise use of the wetlands in their territory. okay? And they also have to promote the conservation of those wetlands by establishing nature reserves, providing adequately for their wardening and so on. So although these are international agreements, they've got very specific obligations in them about what parties, so that is Australia as a party to the agreement, is meant to be doing within its country. And these have repercussions. So this is another one, the protection of world cultural and natural heritage, the UN Convention concerning the protection of world cultural and natural heritage. Now, we looked at this again at the beginning. We looked at what a broad scope of cultural heritage there is, and a broad scope of natural heritage. I won't go through them in detail because we're just there for context. Each party, so again, that's the countries that are a party to the agreement, have to identify these areas, protect them, conserve them, transmit them to future generations, and to do it to the utmost of their own resources. This particular convention says that they shall endeavour, insofar as possible, to adopt a general policy which integrates the protection of that heritage into comprehensive planning programs. So again, there's an obligation there that Australia needed to comply with in terms of having some sort of domestic system in place that allowed it to meet these obligations that it had signed up to at an international level. The UN Convention on Biological Diversity, very similar. This is the one that looks at sustainability and conservation of biological diversity. It also has aspects of genetic resources. These are the duties that are imposed on the government, the duty to conserve biological diversity, to monitor impacts. Again, that's a sort of environmental impact assessment type thing. And a duty to carry out environmental impact assessment of proposed projects that are likely to have significant adverse effects on biological diversity with a view to avoiding or minimising such effects. So this is why we have the EPBC Act. This is why we have a piece of legislation with such a long-winded title in it as well. It's the Environmental Protection and Biodiversity Conservation Act, because they were trying to point to as many of these international agreements as possible to justify why the Commonwealth was interfering in state matters by passing its own umbrella framework for regulating and assessing projects in Australia. So we're going to look at the legislation, and we're going to look at it from the point of view of the flying fox case. So these are the spectacled flying foxes. And I'll just see if I can get the link to work. I'm just going to show you the first sort of 30 seconds of this video. So this video is taken by Carol Booth, who was an independent researcher, and she'd gone up onto a lychee farm, and she had observed this electrified fence that was around the lychee farm and taken footage of these electrocuted and deceased bats that had flown into the grid while they were attempting to get to the lychees within the orchard. Now, if an environmental agency had gone to do this, this evidence would not have been able to be used in court because it would have been obtained unlawfully. But because she was a citizen, she was able to go onto the site and film it and gather evidence, and brought a claim against the farmer for being in breach of the EPBC Act in terms of the impact on World Heritage values from electrocuting significant numbers of these flying foxes. And we'll get back to that later in today's lecture in terms of looking at the outcome of that. So this is the centrepiece of Commonwealth environmental law. The EPBC Act was passed in 1999. This is an image of it, the old school version where we used to get it in paper copy. No one does that anymore because they keep changing the legislation too often. but that's how we all used to carry our legislation around. You'll remember that there's a hierarchy of laws under the Commonwealth Constitution, so if a state law is inconsistent with a law of the Commonwealth, then the Commonwealth legislation will prevail over the law of the state. And it will mean that to the extent that it's inconsistent, that state laws will be considered by the courts to be invalid and of no effect. That means that the Commonwealth legislation will prevail in those instances. What are the objects of the EPBC Act? Well, it provides for the protection of the environment, but it does so through a very particular and quite narrow set of aspects. And it's very important that you sort of get your head around this. The EPBC Act is not about protecting the environment in general, which is what we see at a state level. So the Queensland Environmental Protection Act is about protecting the environment, that broad definition of environment, from environmental harm. The EPBC Act is looking at protecting matters of national environmental significance, or MNES. You'll see the shorthand in the slides. So you really need to get your head around what are the matters of national environmental significance, when are they likely to be impacted, and then what are the repercussions of that. The EPBC Act looks to promote ecologically sustainable development through the conservation and ecologically sustainable use of natural resources. It looks to promote the conservation of biodiversity, to provide for the protection and conservation of heritage, and to assist in the cooperative implementation of Australia's international environmental responsibilities. So again, there's a nod there back to those international agreements that I mentioned. How does it achieve the objects of the Act? Well, it says that it recognises an appropriate role for the Commonwealth in relation to the environment by focusing Commonwealth involvement on these matters of national environmental significance. There's also provisions in there for dealing with Commonwealth actions and Commonwealth areas. It tells us that it adopts an efficient and timely Commonwealth environmental assessment and approval process that will ensure that activities that are likely to have significant impacts on the environment are properly assessed. So how is the environment defined under the EPBC Act? Well, the definition of environment itself is still quite broad. Just remember the offence provisions narrow it down by looking at matters of national environmental significance. So the broad definition of environment is ecosystems and their constituent parts, including people and communities, natural and physical resources, the qualities and characteristics of locations, places and areas, heritage values of places, the social, economic and cultural aspects of anything mentioned above, and so on. It implements Australia's international duties by looking at the protection of native species, so for example endangered species, threatened species, to ensure the conservation of migratory species. It establishes an Australian whale sanctuary to ensure the conservation of whales. It looks at protecting ecosystems, including through the establishment of reserves. Enhances the protection, conservation and presentation of World Heritage properties. Again, that's pointing back to the International Convention on Ramsar wetlands. And it also identifies places to include in the National Heritage List and the Commonwealth Heritage List. Again, looking to protect, conserve and present those places. So all of these is mimicking the wording that we see in those international agreements. So this is what Australia points to when the international bodies turn around and say, how are you complying with your international obligations? It points to the EPBC Act and says, well, look, see, the objectives of this Act are to achieve our obligations under those agreements. How does it look at the principles of EASD? Well, it says that decision-making processes should effectively integrate both long-term and short-term economic, environmental, social and equitable considerations. If there are threats of serious or irreversible environmental damage, then lack of full scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. So that's the precautionary principle there, and we'll look at that more in one of the case studies next week. It points to intergenerational equity. So the present generation should ensure that the health, diversity, and productivity of the environment is maintained or enhanced for the benefit of future generations, and that the conservation of biological diversity and ecological integrity should be a fundamental consideration in decision making. You notice the wording there is should be, not must. So the conservation of biological diversity and ecological integrity should be a fundamental consideration. Okay, so the important slides. So what are matters of national environmental significance? Okay, this is the list of things that are defined under the Act. So World Heritage Places, National Heritage Places, Ramsar wetlands, listed threatened species and listed threatened ecological communities. That includes things like endangered species, migratory species, nuclear actions, Commonwealth marine areas, Great Barrier Reef, and a new one, which is mines and coal seam gas impacting on water resources, which we talked about when we did the coal seam gas lecture. For those of you that might be wondering, nuclear actions means anyone that's trying to create nuclear power stations, and that's a matter of national environmental significance because at the moment there is a ban on nuclear power in Australia. So just remember, the EPBC Act only applies if one of these matters are significantly affected. Okay, so whatever the action is, we talk about controlled actions, whatever the action is, be it a new coal mine or a major road project or some sort of new, boat terminal, anything like that, it's only going to trigger the EPBC Act if the project is likely to significantly affect one of these matters. Okay, so just because it affects some sort of species on the site doesn't mean that the EPBC Act applies. That species has to be listed under the EPBC Act in order for it to be a controlled action. So there are 5 World Heritage Areas in Queensland. We've got our convenient arrows up on the slide here. We've got the Great Barrier Reef World Heritage Area, and then slightly lower down, the Wet Tropics World Heritage Area. Down the right-hand side here, we've got Fraser Island World Heritage Area, and we've got Gondwana rainforests, and then up to the left there, the Australian fossil mammal sites of Riversley. So Queensland's quite well populated with World Heritage areas, and that's probably why in terms of teaching these courses we have the focus on the EPBC Act because of its significance to so many projects across Queensland. This is an example of the National Heritage List that we have in Queensland. Things like Fraser Island, Glasshouse Mountains, and of course things like the Great Barrier Reef and the Wet Tropics and so on. And I've given you the link there in terms you can go and look at the EPC Act list to have a look at the sort of species and so on that they've got on there. In terms of Ramsar wetlands, we've got these 5. So we've got the Bowling Green Bay in Townsville, Shoalwater, the Great Sandy Strait for Fraser Island, and of course you'll be familiar with the Moreton Bay one. Again, you can see there's quite a broad spread of them across Queensland, particularly compared to the other states. This is what the EPBC Act list of threatened species looks like. So it's a sort of interactive list that consultants go to. So they'll do a desktop study of a site, and then they'll use this Commonwealth-led website to start identifying the likelihood of particular species that are listed on the EPBC Act being present on the site. So this gives professionals access to information about which species are listed, where they've been identified, and what their general presence is in terms of how sparse and so on. So if you click into one, so this is looking at koala populations, it's got a number of links there you can follow looking at population information, Australian distribution, habitat, movement patterns, threats and threat abatement and so on and so forth, as well as telling you, importantly, what its listing is under the EPBC Act. So this one, its legal status is that it's listed as vulnerable under the EPBC Act. So it's listed, which would mean it would, if there's likely to be a significant impact on it, then the EPBC Act would apply. This is another example of a listed ecological community, so Brigalow. Again, you've got that excerpt from the website. It's giving you an idea of its general distribution across Queensland, and you can use those sort of resources, again, to do a desktop study to see whether or not these things are likely to be present on the site and whether further studies are necessary in terms of preparing referrals, but also the environmental impact statements that might be necessary for these projects. There's a search tool that, again, this is on the EPBC Act, so you can do a protected matters search tool. Anything in red dots up here is where the ecological community is likely to occur. So this is a search for the Brigalow, which is the threatened ecological community. You can search for that through the EPBC Act website and get that sense of where these communities are likely to occur. You know, it's not, obviously it doesn't give you the complete answer, but it's really about flagging these things to consultants so that referrals are made to the Minister when they are needed to be made under the EPBC Act. So why do we need approval under the EPBC Act? Well, the way that the Act works is it prohibits a person from taking an action without the approval of the Minister or without a decision from the Minister that approval is not needed. And the obligation is put on proponents, so people who propose a project, which is what a proponent is, to refer proposed action to the Minister, for the Minister to decide whether or not it's likely to have a significant impact on the environment. Okay, so you're proposing a project, you're still at the desktop study stage. If you think that you may have a significant impact on a matter of national environmental significance, then the obligation is to refer that matter to the Minister, for the Minister to tell you whether or not you are carrying out a controlled action. So the Minister will decide, will it have a significant impact of matters of national environmental significance? If it will, then it will proceed to an assessment phase. If not, you'll get a letter back from the Minister saying this is not a controlled action under the EPBC Act. Controlled action means it's something that requires approval from the Commonwealth. And so because it's not triggered, it doesn't fall under the EPBC Act. So you have your letter from the Minister telling you. But the person who has to make that decision on whether or not they're going to trigger an impact on a matter of national environmental significance is the person proposing to do the project. Okay, so it's a little unusual that that onus is placed on the person who, as you can imagine, is probably thinking about getting the project ahead as quickly as possible and not necessarily stopping to consider, am I going to impact on some random, threatened ecological community on my site and so on. So it's an interesting approach that they've taken. Of course, we all know why. It's just to do with the resourcing issues that we have in Australia. Now, it's really important that you print out the sections of the EPBC Act that talk about these obligations to have an approval prior to taking an action that will have an impact on a matter of national environmental significance. There's a whole range of them. Section 12, which is just one example, there's a whole range that are in that particular section of the Act. I did have more slides to show you, but they haven't saved onto my external drive. So hopefully they went up on the Blackboard site because I re-uploaded them before this morning. So I'll just have to check. But if not, I'll give you a little note to say which bits that you need to print. Okay, because in the exam you're going to need to know whether or not the facts that you're given mean that you're going to trigger a particular aspect of the matters of national environmental significance, okay? So you'll need to know, is it section 12, is it section 17, is it section something else? You know, this one's World Heritage, there's another one for threatened species, another one for coal seam gas and coal mines impacting on water and so on. So you need to, those parts of the EPBC Act, and you also need to know the assessment parts of the EPBC Act, so the processes for referral and for assessment of the approval. Oh, that bit saved. There you go. You'll need to print copies of them relating to controlled actions and the assessment processes. So who does the EPC Act affect? You know, this is the sort of question that really surprises a lot of industry people, farmers, agricultural industries and so on. It's getting better now, but even so, there's that real surprise that the EPC Act affects them. You know, so the EPC Act applies to anyone whose actions are likely to have a significant impact on a matter of national environmental significance. So it doesn't distinguish between a landowner, a developer, a farmer, a coal miner. Local councils and state governments, they also have to get approval under the EPBC Act if they're likely to have a significant impact on a matter of national environmental significance. So what's an action? This is quite important because you have to sort of get your head around the scope of the EPBC Act. How far-reaching is it? So it includes a project, a development, an undertaking. But the legislation and the case law shows us that it also can include a series of activities. It can include an alteration of a series of activities. So one of the great cases was where, I think it was in Victoria, where they were proposing to build a loop road around the outside of the town. But they only referred one corner of the loop road under the EPBC Act, and they didn't consider that the rest of the development, so the rest of this ring road that was meant to go around the outside of the town, as falling under the controlled action of the EPBC Act. And you know, the legislation clearly tells us now it can be an activity or a series of activities. What information do you have to include in a referral to the minister? Remember, this is right at the beginning when you're starting to collect your approvals under the Commonwealth and the Queensland legislation. What do you refer to the minister to find out whether you're likely to have a significant impact? You're going to have a summary of the proposed action, including any related actions, detailed description. If the state government has given you environmental impact assessment requirements, then you know that needs to be included. If you've undertaken consultation, that needs to be included. You need to state the nature and extent of the likely environmental impacts and the important features of the environment, along with any proposed measures to avoid or reduce the impacts, and we'll look at that a little bit later. But the minister is allowed to take into account the mitigation proposals at the same time as he considers the project itself, and can come to the conclusion that it won't have a significant impact, taking into account the proposed mitigation measures. One of the things that they do look at is the environmental history of the proponent. And I've talked about this before, about how important it is to some developers and sort of repeat large-scale project builders to make sure that their environmental history is fairly squeaky clean, because when they go for approval under the EPBC Act, one of the things that the Commonwealth Minister will look at is the environmental history of the proponent and whether they have any history of non-compliance with any environmental legislation. And in the Adani case, one of the things that happened there was one of the CEOs mistakenly did not notify the Commonwealth of a conviction for breaching environmental legislation over in the UK. Apparently it was an oversight rather than outright lying, but that was something that one of the environmental groups picked up on and it caused a certain amount of embarrassment, as you can imagine. The referral itself, so this isn't even the environmental impact statement, but the referral itself is going to be put up on the internet. There'll be a period of time for public comments to be made, and those public comments can say whether or not they believe that the action is a controlled action. So whether or not it's likely to have a significant impact on matters of national environmental significance. It's an offence to start your action, whatever your action may be, before the minister has made a decision. This is new section 74AA. Why do we have new section 74AA? Because of Mission Beach. In Mission Beach, a project manager put in the referral to the minister and then went ahead and did the clearing of the vegetation in an area that was populated by listed threatened species without waiting for the minister to make his decision on whether or not it was a controlled action. So there's now a separate offence of putting in the referral and then taking the action before the minister's made his decision. What happens in the assessment process? So the minister has to consider all matters relevant to any matter of national environmental significance, but he's also going to consider economic and social matters in that same decision. Now, by this stage of the course, that shouldn't surprise you. So at the same time as the minister is going to evaluate those matters that relate to impacts on matters of national environmental significance, he's also going to take into account the economic and the social impacts that will come from that project. And of course, we're talking about the positive economic and social impacts and how those are balanced up against the impacts on matters of national environmental significance. He has to consider the principles of ecologically sustainable development and to consider the precautionary principle to the extent he or she can do so consistently with the other provisions of the Act. So again, we've talked about the precautionary principle before. It doesn't override the other components of the decision-making process. It's just one of the principles that's taken into account. And sometimes that causes difficulties in terms of what the outcome is in those decisions. Indirect impacts. This is one of the things that's quite important to understand. So this was all to do with the proposal to construct Nathan Dam on the Nathan River. So the allegation that was made by the Queensland Conservation Council was that the minister had failed to consider the impacts of building the dam on downstream, so the impacts of the dam on the Great Barrier Reef. Now, there was a flow of argument, okay? So they said that building the dam was going to lead to the farmers in the region having better access to water, which was going to lead to more productivity and result in more fertiliser use, which in itself would have a downstream impact on the Great Barrier Reef. Now, keep in mind, this case is a few years old. We have a much better understanding now of those downstream impacts on the Great Barrier Reef than we did when this case was decided. Now, when the minister made his decision, he did not consider those impacts, and in fact, I think came very close to saying that he didn't feel he was required to consider them. So the minister's view was that he was only required to consider the direct impacts of the operation of the dam, not the impacts of other persons' activities as a result of the dam being constructed. And so because he only considered the direct impacts of the operation of the dam and not the impacts of other people's activities, he came to the conclusion it would not significantly impact on the heritage values of the Great Barrier Reef area. So the decision in that case pointed out that the minister's approach was incorrect. And so to clarify that, that new definition which we've talked about was inserted into the EBBC Act. So an event or circumstance is an impact if either one, the event or circumstance is a direct consequence of the action, so we're talking about direct impacts, but also it covers things that are an indirect consequence of the action. To the extent that, and so it's got a proviso, to the extent that the action is a substantial cause of that event or circumstance. So they'll consider indirect impacts provided they are a substantial cause of that event or circumstance. So indirect impacts. Okay, so let's just go through the couple of things that we've done. Okay, this is my beautiful Al Gore Island. I think on a Friday afternoon we could all do with thinking about Al Gore Island. Okay, located on the Great Barrier Reef, Al Gore Island is teeming with life and live corals. You can step off the beach and snorkel, swim or dive in an underwater world of brilliantly coloured species of marine life, or just simply relax and soak in the natural island atmosphere. With exceptionally clear water all year round, you may encounter turtles, dolphins, and a large variety of coral, fish, and giant manta rays. If you're there for the right season, you may see birds nesting, turtle hatchings, emerging from the sand, or migrating humpback whales blow and breach. Now, the purpose of this is to consider the concepts that we've just looked at, okay? So it's a little bit of a, and don't you love my bias here with my very eccentric objector and my very posh developer? Okay, so let's look at this one. Okay, so we're going to have construction works, major infrastructure. It's going to be up here north of the river with flow-on impacts down to the Great Barrier Reef. Okay, so we've got our river system leading down here, and down here we've got our corals and our Great Barrier Reef. Is that something that is likely to be triggered under the EPBC Act? Yes, okay. Okay, this one. We've got a new build going in here on our beautiful Al Gore Island. And it's going to be a new, some sort of tourist accommodation, same sort of footprint here, so you can see it's a fairly massive build. Proposal is to do some excavation of the sand dunes here, and it's known that there are turtles that come to lay their eggs here on an annual basis. So is that something that is likely to trigger the EPBC Act? Yeah, okay. See, I'm giving you a quiz that makes you feel good, okay? And last one, what did we start clearing? Well, we decided to start clearing, and our poor threatened species over here uses this for foraging and so on. Potentially? Yeah, okay. See? We all feel good. We've tested our concepts. All right. So one of the other things the Minister has to do is make sure that he does not act inconsistently with Australia's international obligations under relevant international conventions. Remember that you've got a handout for this week up on the Blackboard site. This shows you the structure of the EPBC Act as well as the process for assessment, so referral, assessment, and approval process. You do need to download and be familiar with all of those handouts, and you will need them for the exam. So, we ask ourselves, is it a controlled action? If the answer is no, then the person can undertake the action, but they have to undertake it in the manner described. So let's say that the proposal is to build something over a certain footprint, and then the design is changed significantly so that the footprint of the build is much larger, then they have to go back and make a new referral under the EPBC Act. But if they've referred it and the Minister said, no, it's not a controlled action, then they can undertake the action and they don't need to go any further, provided they do it in the manner described. Okay? If they referred and the Minister says, yes, it's a controlled action, then an assessment of the impacts must be carried out. And the Minister is going to look at the impacts that the action will have or is likely to have on those matters protected by, and we refer to the applicable controlling provisions. That's the sections of the Act that say you must not take an action that impacts on World Heritage, listed species, and so on and so forth. So those are the sections of the legislation that you need a copy of. What type of environmental assessment may be required? So this is set out in Chapter 4, and you'll need the whole of Chapter 4 of the EPBC Act because that sets out the referral, the assessment, the outcome. So the Minister gets to choose which method of assessment is most appropriate. So he can do an accredited assessment process. He can assess it purely on the information in the referral, He can do it based on preliminary documentation. He can go and ask for a public environment report. An environmental impact statement is the most commonly used tool, but if it's something that's very complex or significant or controversial, then he may proceed to a public inquiry. What happens during the public consultation process? Well, that's when you can make your public submissions. And at any time during that public consultation process, if the minister considers that it's too hot, and there are too many submissions coming in, and it's clear it's not a straightforward decision, he can make a declaration that the assessment's going to be changed to a public inquiry. And if you want to have a look at the sort of things that are listed in terms of referrals under the EPBC Act, you can follow that link there. One of the things to keep in mind is that there's an accreditation process in place. So the idea is to speed up the approval process and make it more streamlined between the states and the Commonwealth. So where there's a bilateral agreement in place and it applies to the particular action, then what can happen is the Commonwealth processes can apply sort of in parallel with the Commonwealth ones. Just remember, it only applies to actions which are wholly within Queensland. So if you have something like the Tugun bypass, which was one of the things that I acted on, the Tugun bypass crossed into different territories, and so we ended up having to cut the Tugun bypass in half and have half assessed in Queensland and the other half assessed in New South Wales. So what actions did the agreement apply to? Well, this is just an excerpt of the agreement. You'll note I've got a very useful note for you down the bottom in terms of, you'll be told whether or not the Queensland accreditation process applies. In terms of when we start going through the exams, I'll let you understand how you go about that. So assessment bilaterals. The bilateral approval agreements, there's two. So there's assessment bilaterals and there's approval bilaterals. The assessment bilaterals allow the state's environmental impact assessment procedure to apply, but the Commonwealth Minister retains ultimate decisions on approval or refusal. And then the approval bilaterals allow the state to make the ultimate decision. This is part of their proposals, which was the one-stop shop reforms, which got absolutely panned. So there's no agreements currently in force for approval bilaterals. So there's no states that are allowed to actually make the decision for the minister. But what we do have is our assessment bilaterals that allows the Queensland Government EIA procedures to apply. So they have one environmental impact statement for both procedures. And then the Commonwealth Minister still makes the ultimate decision under the EPBC Act. So it overcomes the problems that we had with there being two EISs, one for the Queensland Act and then one that had to meet the Commonwealth obligations. And there were two different documents with two different tables of contents and two different orders and two different lists of things to consider. What you will find is almost all projects that we have in Queensland fall under this assessment bilateral. That's basically the approach that we'll be taking in the exam as well, and we'll talk about that when we get to the practice exams. So in Queensland, the environmental impact assessment process can be done under a number of different pieces of legislation. It can be the State Development and Public Works Act if it's declared to be a coordinated project, in which case the coordinated assessment process under Part 4A is going to apply. It can be under the Environmental Protection Act or under the Sustainable Planning Act. And you need to be sort of familiar with the fact that it can come under those different things. So again, this is an outline of the EIS process under the EPBC Act and the different processes that apply, and also the time periods between making certain documents available and the minister making decisions and so on. So that's from the handout again for this week, so make sure you've got a copy of it. Sorry, that's not from this week, that's from Lecture 5. That's the one from Lecture 5 on the environmental impact assessment process, which had all the different processes under the Queensland and the Commonwealth. That's right. Okay, so what matters will the minister consider? He's got certain mandatory things that he has to consider. Mandatory means they're not discretionary. He doesn't have a choice on the matter. The minister has to consider matters relevant to anything protected under Part 3 that the minister has decided is a controlling provision, economic and social matters. He must take account of the precautionary principles of ESD, the assessment report, if there is one, and if it's assessment by EIS, he has to take into account the finalised EIS, as well as any recommendation report, and any other information the minister has on the relevant impacts of the action. So if something else has been provided to him through the public submission process, he has to take that into account. And there's been case law on that, particularly with the coal mines, this idea, well, we provided a submission to the minister on the link between greenhouse gas emissions and impacts on the Great Barrier Reef. Therefore, he should have considered that in making his decision and so on. Environmental history, so the minister, in deciding whether or not to approve the taking of an action by a person and what conditions to attach to an approval, the minister may consider whether the person is a suitable person to be granted an approval, having regard to the person's history in relation to environmental matters, and if the person is a body corporate, the history of its executive officers in relation to environmental matters. So that's what's happened with Adani. So although it was Adani that made the referral, the Commonwealth Minister looked at the history of each of the executive officers of Adani, and one of them had been in charge of the UK division when the breach of the environmental legislation had occurred, and that had failed. They'd failed to disclose that on the form. So let's use what we know and look back at the case study that I talked about. So this is from 2001. And here's the lychee orchard up north. You can see Hinchinbrook, Cardwell. It's up near that World Heritage area. So this is it in daylight to give you a better idea. So that's the electrified grid that was put up for the specific purpose of killing the flying foxes that were harvesting the lychees that the farmer was attempting to grow on his orchard. Now the wet tropics, which is adjacent to this area, is on the World Heritage List. It's listed under the UN World Heritage Convention. It's been listed since 1988, okay? So it's something that Australia has undertaken to conserve, preserve, protect, present. Remember, we looked at all those things. So it's something that is a matter of national environmental significance under the EPBC Act. The question was, were the flying foxes something that needed to be protected under the EPBC Act? Okay, so we'll talk about what happened here. So the wet tropics was included on the World Heritage List under all 4 criteria of outstanding universal significance, including, they used the following language when they put in their submission, that it contains the most important and significant habitats where threatened species of plants and animals of outstanding universal value from the point of view of science and conservation still survive. The wet tropics of Queensland provides important habitats for the in situ conservation of biological diversity, including the only habitat for numerous species of plants and animals of conservation significance, which have outstanding universal value from the point of view of science and conservation. Okay, so to when the wet tropics was listed, you can see they're not just talking about it as an area, they're talking about the services, the ecosystem services that it also provides for other types of plants and animals. Okay, and this had an impact in terms of how the court interpreted the application of the Act here. So the Bosworth Farm owned a 60-hectare lychee orchard. They installed the grid for the sole purpose of electrocuting the flying foxes that were flying into and out of the orchard. Carol Booth, who took that footage that we looked at earlier, went before the courts and she applied for an injunction to restrain what she called conduct that has or will have a significant impact on the World Heritage values of a declared World Heritage area. So she was saying that by electrocuting such large numbers of flying foxes, that was going to impact on the World Heritage values of the declared World Heritage area. She was a student, she was a research assistant with the Queensland Conservation Council. She held a PhD in biological sciences, and that's why she was allowed standing to come before the court and make this challenge, because she had a specific interest in these particular matters. So what did she argue? So she argued, one, the operation of the grid is causing injury to and the death of a large number of spectacled flying foxes. And I think she counted well over sort of 300 just in that moment when she took that imagery with the footage there. She said the flying foxes that are being injured or killed by the grid are resident in the wet tropics World Heritage Area. And they, that's the flying foxes, contribute to the biological and ecological function and ongoing evolutionary processes of the wet tropics World Heritage Area. And therefore, the injury and death of flying foxes due to the actions of the lychee orchard owner is likely to have a significant impact on the World Heritage values of the wet tropics World Heritage Area. Now, this was a big one. This was quite an ambitious argument to bring. Certainly, the court had not looked at it from this point of view before. It was very interesting that it was just one individual that was fronting up and doing this and doing it with such, such an ambitious set of pleadings that she put before the court. The question was, could she prove the amount of injury that was being caused to these flying foxes? Could she prove that the number of flying foxes being killed or injured was in itself injuring the World Heritage values of the wet tropics area? Now, she said, okay, I've gone out, I have observed, here's my video footage to prove that I've been there and I've observed that on average there are 377 dead bodies per night across a lychee season, which means that across the 8-week lychee season from 2000 to 2001, around 18,000 were killed, and about 50% of those were female, with the kills occurring in the peak of the birth and lactating season. And I stopped the footage because I actually find it quite traumatic to watch, but there's actually little babies sitting on the ground. The females have been electrocuted and the babies have dropped to the ground, and the mothers are dead. And yeah, it's there if you want to watch it, but I just stopped it after you got a general idea. So were they resident in the World Heritage Area? This is the next thing she had to prove. Okay, so they managed to get expert evidence to prove that the flying foxes were only found in the wet tropics World Heritage Area and in Cape York. And the court then came to the view that the proximity, the closeness of the wet tropics to the farm led them to the conclusion that the flying foxes killed by the grid did in fact reside in the wet tropics World Heritage Area. So she's proven injury to the flying foxes, and she's proven injury to flying foxes that are resident in the wet tropics World Heritage Area. Okay, could she then prove that that the flying foxes contributed to the World Heritage values of the wet tropics area? And to do that, the court looked to the International World Heritage Convention, and they looked at the nomination document that Australia submitted when it said, please list our wet tropics as a World Heritage Area. And this is what the court said. He said, I'm further satisfied that the spectacled flying fox contributes to the World Heritage values of the wet tropics World Heritage Area on the following basis. First, I'm satisfied that the spectacled flying fox contributes to the genetic diversity and biological diversity of the wet tropics World Heritage Area. For this reason, I'm satisfied that the species contributes to the character of the wet tropics World Heritage Area as a superlative natural phenomena, by reason of its being one of the most significant regional ecosystems in the world. Secondly, for the same reason, I'm satisfied that the species constitutes part of the biological diversity for which the wet tropics World Heritage Area is a most important and significant natural habitat for in situ conservation. Okay, so she's gone very far there in showing that the species has an important contribution to make to the wet tropics World Heritage Area. Final step was, is the grid likely to significantly impact on the World Heritage values? The court considered the total population of spectacled flying foxes, and in the context of that looked at how many had been killed and the estimates of how many would continue to be killed. The expert evidence was that it was likely that the total Australian population at that point probably didn't exceed 100,000, with about 50% being female. So the court found that almost 20% of the population had been killed by that electrified grid during the 2000 to 2001 lychee season. Remember, that was an 8-week lychee season. So the court had to look at things like, what does likely mean? And they said likely means, is it prone to? Is it liable to? And they said it doesn't have to mean that it's more than 50% in order for it to be likely. They looked at the meaning of significant impact, and they said, well, the impact needs to be important. It needs to be notable or of consequence, having regard to its context or intensity. They pointed out that the flying fox was part of the record of the mixing of faunas of the Australian and Asian continental plates and constitutes part of the biological diversity for which the wet tropics World Heritage Area is the most important and significant natural habitat for in situ conservation, and that an appreciable reduction in numbers of flying foxes would impact on the World Heritage values of the area. So they come all that way. You can see, I mean, they did well to prove all of those elements and get the court with them, but the question then became, what was the appropriate remedy? And this is where practicality and economics and the balancing of people's interests really all comes into play. Because the electric grids obviously are not the only method for protecting fruit crops from flying foxes. So this is an example of a netted fruit orchard. And it requires more maintenance. This is one of the reasons why they're less popular. It requires a lot more maintenance. And you know, these things are subject to wear and tear, and they can sag and get holes in them and so on, and at which point the foxes can get back in to get the fruit. So, you know, a netted fruit orchard is an option. However, the matter didn't end there. So he was requested to demolish the electric grid, and then they had to take subsequent action against him when that didn't happen. But meantime, something else happened. So this is the Humane Society and Minister for Environment case. So again, we've got our spectacled flying foxes. They're listed as vulnerable species, okay? So, you know, we've had sort of developments there. Now, the Commonwealth entered into an agreement with the states, or in fact had an informal agreement with the states, that there was no need for Commonwealth approval so long as the mortality rate of these spectacled flying foxes or grey-headed flying foxes was not more than 1.5% and would not prejudice the survival of the species. Okay? So basically, they allowed the Queensland government and state governments to issue permits on licences to shoot numbers of flying foxes. And they said in their administrative guidelines, if you're complying with your current state permits or licenses to shoot a specific number of flying foxes, you don't need to make a referral under the EPBC Act for this activity. Provided you do not kill more than the number of flying foxes on your permit, your action would not have a significant impact on the species. Now, I think you will have an inkling from what we talked about earlier today that that's not how the EPBC Act works. The minister cannot say, do not refer this to me. Because if they had referred it to him, what would have been the problem? He would have been obliged to consider whether, in fact, they were likely to have a significant impact. So by not referring it to him, he wasn't put into a difficult situation of having to consider whether, in fact, they were having a significant impact on the listed vulnerable species. And so the guidelines said, do not refer this to me. If you're shooting the flying foxes and, you know, it's not going to prejudice the survival of the species, so work that out with your state government, then I don't need to know. So the Humane Society took them to court and argued that the guidelines were a purported exemption from the operation of the Act, that this was outside the authority of the minister to do this, so that we call it ultra vires in law, but basically it's without power. The minister's response to the court was, no, 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 I'm merely informing permit holders of the view that I would take to assist them in their decision that they must make about whether or not it's a controlled action. Okay, so he's saying, well, yes, they still need to decide whether or not to refer it. I'm just assisting them in deciding whether or not they need to refer it to me. So the court rejected a number of grounds for the challenge. So they held that the minister's decisions were not reviewable decisions. But what they did say that the statements were a strong indication that the minister would not find their actions to be controlled actions if referred. That the principal effect of that was to deter referrals, to stop referrals coming to the minister, and that this was clearly outside the operation of the Act. So they made some fairly scathing comments about the minister and about the fact that they hoped that changes would be put in place. So they said, the society has not suggested that the minister has acted other in good faith. Nevertheless, you always know you're in trouble when the judge says nevertheless, it would seem to me that the statement made in the guidelines to the effect that a person does not need to make a referral to him under the Act goes rather further than advice to persons about how they might deal with the questions posed under the Act. The statement is made by the minister responsible for administering the Act and concerns the legal obligations of persons proposing actions. The minister is effectively saying that he does not require them to refer actions to him for consideration. In my view, in doing so, the minister has purported to exempt them from their statutory obligation. And he goes on to say that whilst the statements made in the guidelines were no doubt intended to provide for a more convenient and efficient course, they do not fulfil any statutory purpose. The powers of supervision and control of actions which might impact upon vulnerable and other listed species do not extend to exemption from the Act. So basically said they were made without the authority of the Act and they cannot have any effect. So yeah, some fairly slamming comments there. So what do you need to do for this week? Make sure that you've downloaded and read the handout that we've got going on the EPBC Act. I'll double check the slides up on the Blackboard site, but if not, I'll give you a little list to let you know which bits of the EPBC Act you need to print, and make sure that you've done some preparation for the practicals next week. All right. Thank you for coming.